Madam President, distinguished members of the court, I shall be responding this afternoon to the observations made by Professor Lowe regarding negotiation conditions. Azerbaijan would wish that you assess differently the two cases in hand, but on the contrary, Armenia is of the opinion that no distinction in this regard can be made between the two cases. In particular, Armenia recognizes that the condition of the failure of negotiations is met in the instant case. I'm sure the court will appreciate the difference. This notwithstanding, Armenia remains persuaded that certain provisional requests stray from the substantive scope of the Convention Against Racial Discrimination. Just to give you an example of this, what kind of link can you establish between the Convention and landmines? My colleagues will go into these aspects in greater detail, so I'll leave it to them. But I cannot prevent myself from pointing out that if we apply the strict criteria, namely link, necessity and urgency, as well as the concrete nature of the measures required, as set out last week by the other side, then the measures requested by Azerbaijan leak like a sieve. Let's apply their criteria to their claims. You will find it edifying. It is indispensable to understand the nature of negotiations in the hellish crucible of these intersecting cases. This is a peremptory reason to deal with it. I should wish to start with to look at four aspects. First of all, the unique character of the negotiations, the dilatory tactics of the other side, the exacerbation of the dispute by that selfsame party, and Armenia's alleged fault in the breakdown of negotiations. So negotiation in these two cases, which you've had before you recently, has never been completely separate, the one from the other. Azerbaijan insisted on the joint nature of negotiations. They only wanted to deal with disagreements jointly. The documents in your possession demonstrate this. Now you want proof. Well, first of all, Azerbaijan notified its claims in the same letter of 8 December 2020, in which it accepted the invitation of Armenia to negotiate on Armenia's claims. But at the same time, Azerbaijan rejected them out of hand. Then, in its letter of 11 June 2021, Azerbaijan particularly insisted on addressing en bloc each party's subject for negotiation. No, indeed, the two series of negotiations related fundamentally to the same subject matter, to wit, the 1965 Convention. Then, in its counter-proposals, Azerbaijan threw into the one pot the issue of the Military Trophies Museum and the VOMA organization. I draw the consequence that the court will not be able to disconnect the two cases when looking at prima facie jurisdiction, because that will be doing violence to this single crucible of negotiations. And after all, the distinction is an artificial one. If you look at the facts, it's only based on tactical considerations and seeks to create an imbalance between the two cases on this point. Disharmony rarely leads to justice. This morning, the other side noted that substantive negotiations did not start immediately after the first exchanges between the two parties' foreign ministers. Why? Well, it was because dilatory tactics were constantly deployed by Azerbaijan to gain the putative advantage of procrastination. You doubt this? Well, your case file in the instant case gives a scathing example. So, it took almost a year, dozens exchanges of notes, and multiple meetings to finally look at the substance of the dispute. The other side slammed on the brakes, obstructed, and dithered constantly. The modalities of negotiation needed to be clarified. Well, let's wait a bit. The continents to be discussed needed to be better defined. Well, okay, let's postpone. Negotiators had to be of the same grade. Patience, everybody. Well, I will not waste your time revisiting all this in detail, but let's compare it to the attitude of Armenia. Armenia attempted, as of the get-go, to deal with the substance of the dispute without circumvolution, without meanders, without leading up garden paths. In all of this, I see someone who is going straight towards a settlement, and I see someone who is trying to evade it. I also see someone setting traps to avoid that Article 22 of the Convention have any useful effect. On top of this, Azerbaijan did not wish that its attitude seeking delay and postponement saw the light of day. They insisted countless times on the confidentiality of the documents used in negotiations, and these questions relative to confidentiality also contributed to the eating up of time. Throughout the negotiations, Azerbaijan continued to aggravate the dispute by acts which were sometimes untimely, often questionable, and always varied. Let me give you 3 examples. First of all, the inauguration of the military trophies park. Recently, Azerbaijan removed some mannequins which were causing a scandal. Nothing could be clearer to bear witness that their presence inflamed and worsened the dispute. Is this how to create an atmosphere favourable to seeking agreement between two parties? I ask you. Then, the destruction of Armenian cemeteries and other cultural assets. A specific reference should be made to the decapitation of Shushi's cathedral and of the genocide memorial. And finally, the ill treatment meted out to prisoners and detainees. One would have you believe that the fault for the failure of negotiations falls on Armenia. This is a pretty sorry argument. Why in negotiations would it be simply the other's fault? Let me recall, moreover, that it was Armenia who initiated these negotiations. This suggests palpably who was interested in making progress. Why didn't Armenia make any proposals after the counter-proposals from Azerbaijan? Well, there is no obligations to make counter-proposals to counter-proposals after almost an entire year of negotiation. Even less so when you know what Azerbaijan was doing with the one hand whilst pretending to negotiate with the other. Armenia realized that Azerbaijan did not want to negotiate on its claims. The counter-proposals of the other side sought precisely to move the negotiators further away from that perimeter. Look closely at the counter-proposals. They wandered way beyond the markers of the 1965 convention. Nothing on humane treatment or the repatriation of prisoners of war. Nothing on stopping the destruction of cultural property. Nothing on stopping their president's hate speeches. Thus, Armenia had good reason to think that no use would be served by continuing sterile negotiations. Firstly, on account of the undermining fieldwork of the sappers, then procrastination and the red herrings, and finally by the deflection of the subject of negotiations. And this all the more so given the urgency of the situation, those threats weighing on the rights in play. In these conditions, I have trouble seeing how one can successfully argue the maxim of one's own wrongdoing against Armenia. But fair enough. If Azerbaijan thinks they can argue it, I think Armenia can rely on this maxim even more so. My earlier arguments prove it. In sum, the requirements for negotiations were met in the reasonably transparent context of Mavramatis or Qatar versus UAE. Why wouldn't it be the case here? Even more so. So these reflections bring to an end my oral presentation. I would like to thank you for your kind attention.